was high risk or high need such that he needed any sort of detox or follow-up or anything of that nature. This is a situation where he's engaged with his tribe in Minnesota, appears to be doing very well. I don't think that there'd be any benefit to placing him on probation at this point and returning him to Burnett County. So I think this is an appropriate resolution, and I urge the court to adopt it.
Thank you. Mr. Mary, do you care to make any statement here today? You don't have to, but it is your only time to tell me anything.
No, ma'am, I'm fine with everything.
All right, thank you. All in all, in looking at the facts of this case and knowing what you did going and doing the AODA assessment and that follow through and having some connection with mental health specialists as it relates to any alcohol and or drugs, I don't find this to be an extremely serious case. You do live in Minnesota, in Hinckley, Minnesota. In Hinckley, Minnesota, THC is legal. In Wisconsin, it is not legal. Therefore, you can do what you will in the state of Minnesota as it relates to marijuana and THC. You cannot in the state of Wisconsin. So I believe that the crimes that you pled to and having criminal charges is punishment enough, along with the fines and fees and court costs that you will receive as it relates to this and to these matters. You originally had $250 posted. That was ordered forfeited, I believe, around May 22nd, 2024 for a failure to appear. What I'm going to do is I have not yet received an order from the state to completely forfeit that, to have that go to the county general fund. So I'm going to set that forfeiture aside. So I have a total of $750. I'm going to assess $443 in court costs and fees for count 2. I'm going to assess $307 for count 3, and I will waive the remaining court costs and fees for count 3. That means you're going to be paid off in full for your fines, fees, and court costs. I don't think that you should have any other penalty associated with these crimes, because you are being accountable and you're being responsible and you are pleading guilty to crimes, and they are now on your record. You have 20 days to appeal. Should you fail to appeal in 20 days, you do lose that right. I do have to order that you provide your DNA to the Sheriff's Department, the Burnett County Sheriff's Department. I'm going to give you 60 days to do so. All you need to do is call the Burnett County Sheriff's Department and see if they need your DNA. If they do, they'll let you know, and you can arrange a date and time to come up here to provide a sample to them. It's just a little swab in your cheek, and it would be something that you can apply in a written letter to the Department of Justice to have it removed from the CODIS system, if that's something that you wish to have done. But you still need to provide that DNA sample to the Sheriff's Department per statute. Again, 20 days to appeal. Talk to your attorney about that. I am also going to order 4 days of jail for count 2 and for count 3 to run concurrent. You have 4 days of jail credit. You might as well get the credit for the